My name is Fawaz Maarouf. I'm a senior attorney at Oliva Gibbs. Today I will be discussing the history of land title in Texas. Oliva Gibbs is a law firm built for upstream oil and gas. Oliva Gibbs serves clients in every major U.S. basin, has attorney's license in over 15 states, and has supported operators, landmen, mineral buyers, and in-house counsel. Services include title opinions, transactions, regulatory compliance, and litigation, everything oil and gas. A little about me, I attended the University of Central Oklahoma for my undergraduate degree, and I attended Southern Methodist University School of Law for my law degree. I'm currently licensed to practice law in the state of Texas. I have over a decade of experience in the oil and gas industry, including over a decade of experience as a layman in the state of Oklahoma and in the state of Texas. My experience is in examining real property records, curing title defects, drafting title documents, reviewing title policies, negotiating leases, and facilitating complex mergers and acquisitions. Here's a list of the topics that I will be discussing with you today. First, I'll discuss the Six Flags over Texas, referring to the six nations that have held sovereignty over Texas. Next, I'll discuss how the Texas Constitution and other various acts led to the Relinquishment Act of 1919 and the end of the Relinquishment Act era. I do want to focus on the Relinquishment Act era, how to identify those patents, and what those leases will look like. So let's begin. First, let's discuss the Six Flags over Texas. Six Flags over Texas refers to the six nations that have held sovereignty over Texas. The first two flags are Spain and France. Spain held sovereignty over Texas from 1519 to 1821, interrupted by France, who briefly claimed part of Texas from 1685 to 1690. Spain was the first European nation to claim and colonize Texas. In 1720, the first grain was given out of in Texas to the San Jose Mission in San Antonio. Here, the rule was that the mineral rights in the land did not pass by an ordinary grant of land without express language. Again, the mineral rights in land did not pass by an ordinary grant of land without express language. It was implied as a reservation of mineral rights to the sovereign, regardless of what the patent stated. Next, the third flag is Mexico, who governed Texas from 1821 through 1836, after gaining independence from Spain. Thereafter, conflicts led to the Texas Revolution. During this time period, the same rule applied. The mineral rights in land did not pass by an ordinary grain of land without express language. It was always an implied reservation of mineral rights. The fourth flag is the Republic of Texas, who held sovereignty over Texas. Following its victory in the Texas Revolution, Texas became an independent nation with its own government, establishing the Sovereign Republic of Texas. Again, during this time period, the Republic of Texas adopted the rule from Spain and Mexico, meaning the mineral rights in land did not pass by an ordinary grain of land without express language. It was, again, an implied reservation of mineral rights. Finally, the last flags are the Confederate States of America and the United States of America. Here, Texas was admitted as a 28th state in 1845 through present, interrupted briefly when Texas seceded from the United States of America during the Civil War and joined the Confederate States of America from 1861 to 1865 until readmitted to the Union. Here, a couple key points are the following. Texas is the only state that retained ownership of its vacant public lands rather than ceding them to the federal government. Again, Texas is the only state that retained ownership of its vacant public lands rather than ceding them to the federal government. And secondly, Texas continued to recognize the grants of prior sovereigns rather than voiding them, and for the sole purpose to not create any confusion. So the rule of Spain, Mexico, Republic of Texas, and State of Texas that mineral rights and land did not pass by an ordinary grant of land without express language still applied. Accordingly, it was still implied that reservation of mineral rights through patents was implied without any express language needed. So that's my discussion of the Six Flags Over Texas, which leads us to the historical background of what happened in the 1866 Texas Constitution. So now Texas, as a 28th state, had the 1866 Texas Constitution, which changed the general rule of an implied mineral reservation. However, this changed the rule going forward, not backward. So from 1866, patents conveyed surface and minerals unless the minerals were expressly reserved. Again, this was all prior to the 1866 Texas Constitution, where the minerals still had an implied reservation, but from the 1866 Texas Constitution and forward, now patents conveyed surface and minerals unless expressly reserved. But prior to 1866, the Texas patents had an implied reservation of minerals. Now, the issue was that the surface owners prior to the 1866 Constitution did not receive any ownership in mineral rights, although the mineral rights were not expressly reserved. This leads us to the Texas Constitution of 1876. The Texas Constitution of 1876 did two main things. Number one, it released minerals. The state of Texas hereby releases to the owner or owners of the soil all mines and minerals that may be on the same, subject to taxation as other property. This means that the state released to the surface owners of lands previously sold the mineral rights. Accordingly, the surface owners automatically received mineral rights to lands that were previously sold. So this applied retroactively to all patents without an express mineral reservation. But the Texas Constitution of 1876 did another thing as well. While it solved the problem, as stated, releasing all the minerals previously, it also established a perpetual public school fund. It reads as follows: all funds, lands, and other property heretofore set apart and appropriated for the support of public schools, all the alternate sections of land reserved by the state out of grants heretofore made or that may be hereafter made to railroads or other corporations or any nature whatsoever, one half of the public domain of the state, and all sums of money that may come to the state from the sale of any portion of the same, shall constitute a perpetual public school fund. Here, the state of Texas set over 42.5 million acres of unsold land as public free school land. And the state of Texas also provided that sales of these public free school lands would be set aside in a permanent school fund. So these were the two main points the Texas Constitution of 1876 accomplished, releasing to the surface owners of lands previously sold the mineral rights and establishing the perpetual public school fund. Now we're going to discuss the 1895 Land Act and how it plays in with the Texas Constitution of 1876. So enacted in September 1, 1895, were the 1895 Land Sales and Mining Act, where they added a mineral lands classification. So basically, lands can be classified as quote unquote mineral lands or mineral classified lands. And if the lands were mineral lands or mineral classified lands, the state of Texas must retain all minerals when it is sold. Now, certain lands can be classified as mineral lands. So, how did this come about? Texas realized the value of all these mineral lands, specifically in West Texas. They realized the value of oil and gas and classified certain unpatented land as mineral lands accordingly to retain these minerals for the public perpetual public school fund established in the Texas Constitution of 1876. Now, it is possible for a patent, again, to not include a mineral reservation and the state to still have reserved the minerals. Basically, mineral classified lands include an implied reservation. So it seems like we're working backwards here because the Texas Constitution of 1876 released all the minerals to prior service owners automatically. Now it's saying if we classify these lands as mineral lands or mineral classified lands, it is an implied reservation regardless of what the patent says. So this does seem to contradict what the Texas Constitution of 1876 set out to accomplish when releasing to surface owners of lands previously sold the mineral rights therein, rather than prior patents implicitly reserving minerals. So the Texas Supreme Court chimed in Cox v. Robinson in 1912. It said, it stated that while the Constitution of 1876 released mineral rights to prior surface owners, the Constitution of 1876 did not ban the legislature from reserving minerals in the future. So they said this was fine. There was no ban in future reservations of minerals, which this act essentially did. Now, this 1895 date is a pivotal date where the state required buyers applying to purchase mineral classified lands to file a waiver confirming that no actual minerals were known to be located on the land at that time. Almost all lands not previously sold by the state of Texas by 1895 were located in West Texas, and the state classified most of those lands as mineral lands. Basically, if the lands were classified as mineral lands, the statutes provided that the state of Texas must retain all the minerals when sold. So, reading the 1876 Texas Constitution and the 1895 Land Sales and Mining Acts together with the prior history we went over, at this point, prior to 1895, all patents for lands in Texas included the mineral rights. And after 1895, if lands are classified as mineral lands, the minerals are reserved by the state as an implied reservation in the patent. This did upset the surface owners because it did seem like it was working backwards. However, the state of Texas passed another act, the 1907 Land Sales Act, hardening the classification of mineral classified lands. The state of Texas basically doubled down by passing the 1907 Land Sales Act, It said that the General Land Office, the GLO, may classify lands as mineral lands and sell them. However, an express mineral reservation in every application to purchase mineral land is now required to remove any ambiguity that buying mineral classified lands meant only buying the surface, not the minerals. So it was clear that that was the way they were going forward, and the surface owners were not happy about that. They wanted a stake in the mineral rights, especially during the boom, especially in West Texas, where the minerals were worth a lot of money. Now we're going to move forward and discuss how this applied as far as early leasing of state lands after Texas Constitution of 1876 and after the 1895 Land Sales and Mining Acts, where we have mineral classified lands. So there was an issue. The state of Texas essentially had no mechanism for authorizing the development of state minerals. They needed to develop these state minerals to fund the perpetual school fund, but they had no mechanism for authorizing it. So the solution to that is permitting and leasing acts of 1913 and 1917. These generally allowed private individuals or companies who wished to explore state minerals to apply for a permit. If oil or gas were discovered, the permittee could request a lease. So this did authorize the state of Texas to bypass the surface owner, and it also authorized the state of Texas to issue oil and gas and mineral drilling permits directly to third-party individuals or companies on mineral lands. Now, what did they do? They gave payments to the surface owners of 10 cents per acre per year for the life of the lease. Again, the only compensation to the surface owner was 10 cents per acre per year for the life of the lease. The Land Sales Act of 1919 clarified that the remaining public school land sales would reserve minerals to the state. Mineral land classification for public school land was no longer necessary. Again, the state doubled down strict state mineral reservations. So, what was the main issue here? The main issue was the surface owners were getting shut out of the oil wealth beneath their land and they were paid almost nothing for the disruption, including for the surface damages. Again, it was only 10 cents per acre per year for the life of the lease. The surface owners pushed back and they asked the state to give them a financial stake in mineral leasing. They were seeking some stake, some kind of ownership, some kind of compensation. At this time, the surface owner's compensation was 0% royalties, no lease benefits whatsoever. They own no mineral rights. They basically got 10 cents per acre per year for the life of the lease for surface damage compensation. Surface owners were angry. Not only did they not have minerals in the land, they were not properly compensated. So what did they do? They started revolting. The surface owners began refusing entry to their land. And this caused friction because the state had an interest in developing these minerals, and now the minerals were undeveloped due to the surface owners refusing entry and refusing to comply. So now we had undeveloped minerals and angry surface owners, and essentially, state of Texas knew that this was affecting the public education funds because the minerals were undeveloped. The state of Texas also had a lack of manpower and resources to negotiate all of these leases and to administer all of these leases. They were just simply not equipped to do so. All of this led up to the Relinquishment Act of 1919. And the Relinquishment Act of 1919 was enacted in July 13, 1919. The goal of the Relinquishment Act was to promote the active cooperation of the owner of the soil, which is a surface owner, and to facilitate the development of its oil and gas resources. Again, we need cooperation from the surface owner, we need entry, and we need um, help developing the minerals. So we need someone on the ground to negotiate these leases, to administer these leases. The state of Texas quickly recognized that to incentivize surface owners into allowing oil and gas operations on their land, their interests, the surface owners, and the state of Texas's interests needed to align quickly. This Relinquishment Act of 1919 accomplished that. However, the language of the Relinquishment Act of 1919 was as follows. It made the owner of the soil, the surface owner, the agent for leasing the land for oil and gas development. That means they would negotiate the lease, sign the lease, they would be the agent, the surface owner would be the agent of the state. The language said, in lieu of surface damages and as compensation for acting as agent, the surface owner would be awarded an undivided 15/16 of the minerals. The state of Texas would retain only a 1/16 free royalty. The agent was authorized to sell or lease the oil and gas in place with one restriction, being the state was to receive 10 cents an acre as a rental, as well as its 1/16 royalty. And the Texas Constitution dedicates school lands and proceeds to the permanent school fund. So the Relinquishment Act of 1919 by its text appears to relinquish 15/16 of the minerals to the surface owners. So it does seem like by its text, it is giving away minerals to the surface owners, which are for the permanent school fund. So this was challenged very quickly for violating the Constitution, the Texas Constitution, because the language would seem that it would be violating it. So there was a Supreme Court case, Texas Supreme Court case, Green v. Robinson in 1928. And the main thing it did here was it was mostly for interpreting the language of the Relinquishment Act of 1919. They wanted to interpret what this meant and if it was constitutional or not. So instead of striking down the Relinquishment Act of 1919 as unconstitutional, the Texas Supreme Court decided to construe the act in a way that would pass constitutional muster. And it held that it did not relinquish the oil and gas to landowners. As you remember, the language does seem to indicate that it does relinquish the mineral interest. So the court held that it makes the surface owner the state's agent for leasing, and title to the minerals never leaves the state or permanent school fund because it's just an agency relationship which runs with the land. The agent, in essence, gets one half of the lease proceeds, one half of the bonus, one half of the royalty, and one half of the rentals of oil and gas leases as compensation for acting as an agent, while the permanent school fund's mineral interest stays intact. That was their interpretation. And the canon applied is this: the court said it would resolve all reasonable doubts in favor of its validity. And where a statute is susceptible of a valid construction, that construction wins, even if it's not the most natural reading of the text. Here, rather than the court striking down the act, the court chose to read it narrowly. So the three points I want to bring up in this case are the following. One point is they it was argued that this is an unconstitutional gift because hey, we are gifting mineral rights based on the text of the act. However, the court did say the surface owner owns no oil or gas, so no vesting did occur. They're just an agent, and the state of Texas still owns 100% of the mineral estate in these Relinquishment Act lands. What did the court focus on? It focused on the purpose of the act, reading the entire act as one, so as to determine what the legislator intended rather than what they actually said by the text. So, in summary, as far as this being challenged as an unconstitutional gift, there was no vesting of title or interest in the oil and gas in the owner of the soil. Because the state retained ownership of all minerals, there was no unconstitutional gift. To reach this conclusion, again, the court just focused on the overall purpose of the act. They read it to determine the intent of the legislator instead of focusing on the actual text of the act. Another point that was brought up is this is unconstitutional because it diverts public school funds in an unconstitutional and unauthorized manner. It's essentially giving these public school funds to the surface owner as compensation. The court responded by saying that payments made to the surface owner are in lieu of damage to the soil, liquidated damages, not payments of sale proceeds of oil and gas. So instead of, hey, here's your 10 cents for surface damages per year for the life of per acre for the life of the lease, we're instead giving them payments in lieu of these damages in the form of one half of lease benefits. And also, the court did say the lease benefits are essentially split equally between the state and the surface owner. So, in summary, the payments made to the owner of the soil, which is a surface owner, are just payments in lieu of damages to the soil, not sales proceeds. Therefore, there was no unconstitutional diversion of public school funds in an unconstitutionally authorized manner. To make this determination, the court also looked at the legislator's intent, finding that the payments were not part of the consideration for the sale of oil and gas or leasing of oil and gas. The third point I want to bring up is it was argued that this is delegation of duties imposed by the Constitution to the legislature. Basically, the legislature was supposed to act as an agent, and you're not supposed to divert these duties to the surface owner. The court responded as follows: compensation such as bonus, royalty, and rental under the lease is to be paid equally to the state and the owner of the soil, the surface owner. Therefore, there was no unconstitutional delegation to the agent of duties imposed by the Constitution on the legislature. The court also stated that the Constitution has never been construed to require that the legislature should prescribe in detail and with exactness the consideration or the price of which these lands should be sold. Therefore, the court found valid the sales of the minerals for the best price made by the surface owners, acting as their agent authority, with the legislature having prescribed the minimum terms upon which the state was willing to sell the land. So, in essence, the Relinquishment Act of 1919 was upheld by Green v. Robinson, Texas Supreme Court. They read it very narrowly, they wanted it to stay. And in summary, the rule derived from Green is that the owner of the surface of lands subject to the Relinquishment Act is simply a leasing agent for the state, and the surface owner is entitled to one half of the benefits of the lease, and those benefits and agency run with the land. And it also The act applies only to public free school and asylum land sold with a mineral classification or mineral reservation during the period of the act. Green also established that the Relinquishment Act would apply to public free school land sold both before and subsequent to this act. This confirmed September 1, 1895 as the beginning date of the Relinquishment Act era. And as a reminder, 1895 Land Sales and Mining Acts was enacted in September 1, 1895. That's where that date comes from. So now the Relinquishment Act of 1919 um, rules applied. So in 1931, it was attempted to strike it down with the Relinquishment Act of 1931. So the Relinquishment Act of 1919 was challenged by the Relinquishment Act of 1931, and the Relinquishment Act of 1931 challenged the Texas Supreme Court holding in Green by vesting title in the landowner as to 15/16 of all minerals underlying the land. So basically, it said we're going to vest the surface owner with 15/16 of all minerals. This was quickly challenged and declared unconstitutional in Empire Gas and Fuel Co. v. State in 1932. Essentially, why it was unconstitutional was a Relinquishment Act of 1931 attempted to retroactively grant 15/16 of mineral ownership on already sold Relinquishment Act lands. Simply, the state of Texas could not give away school fund minerals that it has already reserved. It cannot apply retroactively. This led to the 1931 Land Sales Act, changing how the state sells public land in the future, not retroactively. Essentially, the legislature can change how it sells public land moving forward, as it's doing in the 1931 Land Sales Act, which we'll discuss next, but it cannot give away land that it has already dedicated to the public. It cannot apply in retrospect, in a way attempting to give away state property. So again, Relinquishment Act of 1931 was held unconstitutional. Relinquishment Act of 1919 was going on until the 1931 Land Sales Act, which we just discussed. Sales and Leasing Act of 1931 amended the Relinquishment Act of 1919, and this is the end of the era of the Relinquishment Act. It provided that thereafter, not in retrospect, um, public free school lands would be sold with a reservation of a 1/16 of all minerals as a free royalty to the state of Texas, thus relinquishing or vesting to the surface owner the remaining 15/16 of all oil and gas. So essentially, the 1931 Land Sales Act reserved a 1/16 of all minerals as a free royalty to the state of Texas, and it vested the surface owner with a 15/16 fee title to all oil and gas, but it must be stated therein. So this is a big change from the Relinquishment Act of 1919, and this ended the Relinquishment Act of 1919 era. In 1983, the 1931 Land Sales Act was amended to change the reservation of a 1/16 of all minerals as a free royalty to be not less than a 1/16 free royalty of all minerals. So it gave a little flexibility in the free royalty reserved, where it could be more, but it must be at least 1/16 free royalty reserved to the state. Thereafter, the General Land Office, or the GLO policy, was to go ahead and reserve all the minerals in those lands. And just to summarize, the Relinquishment Act era The Relinquishment Act of 1919 era ended at when the 1931 Land Sales Act was enacted, and the 1931 Land Sales Act provides that public free school lands would be sold with a reservation of 1/16 of all minerals as a free royalty to the state. The remaining 15/16 of oil and gas is relinquished or vested to the owner of the soil, being the surface owner. Therefore, any sales after the 1931 Land Sales Act or after May 29, 1931, the 1931 Land Sales Act controls. So basically, for sales between September 1, 1895 through May 29, 1931, when the Land Sales Act of 1931 was enacted, were the relinquish this is a time period when the Relinquishment Act of 1919 still controlled. It's important to note that the Relinquishment Act of 1919 was not held unconstitutional. It still applies just during that time period, September 1st, 1895, through the date the 1931 Land Sales Act was enacted. So the net outcome, and now it's time just to focus on the Relinquishment Act lands. It's going to be from 1895 to 1931, when the Relinquishment Act of 1931 was enacted. During that time period, for sales of mineral classified public free school lands after September 1st, 1895, but before May 29, 1931, the state of Texas owned 100% of the minerals in fee, but the surface owner has the right to lease those lands and receive one half of the lease benefits, being the bonus, rentals, and royalties, in return for acting as an agent for the state of Texas. And that compensation of the surface owner is in lieu of surface damages. They cannot get surface damages and get these benefits simultaneously. So that's a net outcome of the Relinquishment Act of 1919. So let's see how it applies practically going forward. The GLO, this is an example of a GLO standard Relinquishment Act lease form. So the surface owner is authorized to act as a state's leasing agent on such terms and conditions as the surface owner deems. They have a little bit of flexibility. The bonus for the oil and gas lease on these lands is up for negotiation. However, the lease must be on the General Land Office lease form as you see on the screen. Um, and and it must contain the highest royalty in the area. So while there's a little flexibility, it has to be on this form, and no lease, no oil and gas lease is effective until it's accepted for recording by the General Land Office. So the General Land Office does need to accept it for recording. The General Land Office will refuse to accept any lease if they believe the lease is inconsistent with the state of Texas's best interest. So they have that discretion to do so. Let's talk a little bit about the lease guidelines or the lease terms, the Relinquishment Act lease terms. So the primary term must be of more than 5 years. The lease may not encompass more than 4 full sections or 2,560 acres. A Mother Hubbard or coverall clause in the lease is not acceptable. Also, private land and Relinquishment Act land cannot be included in the same lease. Also, top leasing is forbidden. Basically, you cannot top lease this lease, or in other words, you cannot execute a new lease while this prior lease is still in effect. Also, collateral agreements are forbidden. For example, you cannot have surface use agreements, easement agreements, anything else outside of the four corners of this lease. Everything, all the terms must be within this lease. So no collateral agreements. The lease must adequately reflect the actual consideration paid or promised for the lease. The state and the surface owner must share equally in all consideration paid under the lease. However, the surface owner may waive or defer his or her share of the bonus at any time after pre-approval and before filing with the General Land Office. The adequacy of the consideration may be reassessed by the commissioner. So basically, any lease benefits or any consideration must be shared equally. Amendments are allowed to Relinquishment Act leases. Now, if the amendment has to do with some typographical error, then the amendment can be done easily. However, the issue is if the amendment has to do with a substantive issue. Then the General Land Office will want to look into the proposed amendment and decide if they want to allow it or not. Whether the General Land Office allows an amendment or does not allow an amendment depends on what stage the lease is in and the type of proposed amendment. They have full discretion, the General Land Office at that time, whether they want to allow a substantive amendment or not. Also, he said that the General Land Office does not have any sort of formal approval process for an amendment, but the surface owner, as agent of the state, will have to confirm the amendment with the General Land Office before the General Land Office will file the proposed amendment in their lease file. Therefore, even though there's not a formal quote unquote approval process, the General Land Office will need a sort of tactically approve any proposed amendments. Those are just some general lease guidelines of these Relinquishment Act leases. Next, let's talk about the agency relationship. As discussed, the Relinquishment Act of 1919 creates an agency relationship with the surface owner and the state, where the surface owner is the state's agent in leasing. The Relinquishment Act creates an agency relationship between the owner of the soil and the state of Texas. And an owner of the soil owes the state a fiduciary duty and a duty of utmost good faith. Any conflict of interest must be resolved by putting the interests of the state before the interests of the owner of the soil. Basically, this was the text, and the surface owner owns the state a fiduciary duty of utmost good faith. To put in perspective, that's the highest duty, and the surface owner must act in the state's best interest, basically leasing on good terms to a good operator. Now, if the commissioner determines that the surface owner has breached its duty, commissioner may request the attorney general to file an action to enforce, and the surface owner may be liable for punitive damages. Now, with the common type of conflict of interest here, I would the surface owner, let's say, attempts to negotiate a separate surface damages provision or agreement on the side. Now, again, per the Relinquishment Act of 1919, lease payments to the surface owner are in lieu of surface damages. They cannot get both. And per the General Land Office, participation by the owner of the soil, the surface owner, in the bonus, rentals, and royalties is in lieu of surface damages, and such collateral agreement could render the lease invalid and subject the surface owner's agency rights to forfeiture. So, surface damages have already been accounted for. They're accounted for by giving the surface owner payment of half the royalties, bonus, and rentals in return for acting as an agent, instead of surface damages, which were originally 10 cents an acre, uh, 10 cents per acre per year for the life of the lease. So this introduces a motive for the surface owner to seek additional surface use damages in exchange for a lower bonus or royalty, and this would essentially lead to an unequal split of lease benefits where it's supposed to be 50-50, 50% to the state, 50% to the surface owner being the agent, thus violating the agency. Just a practical rule, there should be no collateral agreements. All terms must be in the lease. Now we'll discuss that regarding self-dealing and its prohibition. A surface owner cannot lease to family members or corporation in which he or she is a principal stockholder or himself or herself or a nominee. However, a surface owner may request approval of the board for authority to execute such a lease, but they must execute a sworn affidavit that the surface owner will not receive any benefit under a lease that will not be shared with the permanent school fund. Again, it's always going to be 50-50, so 50% benefits to the state, essentially the permanent school fund, and 50% to the surface owner for acting as an agent. So this is just a strict prohibition against self-dealing. A surface owner as a state's agent may not engage in self-dealing either directly or indirectly. The surface owner will be considered to have engaged in self-dealing if the surface owner, directly or indirectly, leases or assigns a lease executed by that surface owner to themselves or to any of these following people, which would be the indirect portion, being a nominee, any corporation or subsidiary. It would a partnership in which a surface owner is a partner or an employee of such a partnership. If the surface owner is a corporation or partnership, a principal stockholder of the corporation or a partner of the partnership, or an employee of the corporation or partnership. Next, a fiduciary representing the surface owner, including but not limited to a guardian, trustee, executor, administrator, receiver, or conservator. A person related to the surface owner within and including the second degree of affinity, including a person related by adoption. A corporation or subsidiary in which that related person is a principal stockholder. A partnership which that related person is a partner, or to an employee of such corporation of subsidiary or partnership. Subject to the limitations against self-dealing, the surface owner is authorized to act as a state's leasing agent with any person desiring to develop or explore for the oil and gas. That's standard lease negotiation procedure. Now let's discuss an available owner. Relinquishment Act of 1919 addresses this scenario in section 52.186. If unavailable by the terms of the statute, agency rights are forfeited and the oil and gas can be leased under the procedure for leasing unsold surveyed public school lands. Subsection B explains the requirements in which an owner may be legally deemed unavailable. They're unavailable if the operator proves up unavailability under the statute, commissioner provides written notice to the owner of the soil, explaining the consequences of finding him unavailable. Notice is sent to the owner's last known address and provided by publication. The owner of the soil has 30 days to contact the general land office. If no reply, the agency rights are terminated and process goes to sealed bid by school land board. There is a 2-year redemption period for surface owner if he or she can prove and there was improper notice somehow. Now let's talk about conveyancing of Relinquishment Act lands. Generally, the rule is this. If you want to convey Relinquishment Act lands, mineral deeds and reservations from surface owners for Relinquishment Act lands are void. Because the court in Green established that the surface owner has no right to oil and gas, they were never vested anything, the surface owner cannot sell the minerals. There is an exception. The surface owner's rights, including rentals, royalties, and bonuses for acting as a state's agent in leasing under an existing lease, keyword is existing, may be conveyed or reserved apart from the surface rights, but said rights revert to the current surface owner upon expiration of said lease. The surface owner cannot make an assignment of a perpetual royalty that will outlast the existing oil and gas lease, or convey or reserve any sort of royalty if no oil and gas lease is in existence. Basically, they can assign their lease benefits that they were paid for being an agent during the term of the lease or during the life of the lease, not after. And to discuss free royalty leasing, a free royalty is treated the same as an NPRI, a non-participating royalty interest, wherein the mineral owner executes a lease and the state only participates if there's production in the lease. Now, Permanent School Fund gains revenues from a portion of production depending on the free royalty reservation, which is generally usually a 1/16th free royalty or 1/8 free royalty interest. So here it's just important to know that a free royalty is similar to a non-participating royalty interest. Okay, so here is a sample of a Relinquishment Act patent. So this one specifically you'll see highlighted in yellow, and I'll read it out. It says, the oil and gas that may be in the above described land are subject to Chapter 81 Act approved July 31, 1919, which was when the Relinquishment Act of 1919 was enacted, and continues to say, and other minerals are reserved to the fund to which the land belongs. It's essentially saying this is Relinquishment Act lands, so it's subject to everything we went over, the lease form, lease guidelines, self-dealing prohibited, and so forth. So this will show you, okay, now I'm dealing with Relinquishment Act lands, and this is how I treat them accordingly. Now, here's an example of a free royalty patent. On the bottom highlighted, it says 1/8 of all oil, gas, sulfur, and all other minerals is reserved as a free royalty to the state. This shows you that, hey, this is just a free royalty. It's treated similar to a non-participating royalty interest, and I'll treat these lanes accordingly going forward. So in essence, it's important to understand the Six Flags Over Texas leading up to these pertinent acts. Specifically, we went over the 1866 Texas Constitution, but the main one is the 1876 Texas Constitution, which created the perpetual fund for the school lands. It released the minerals automatically to the surface owners of prior patents, where it was silent to the reservation. And then 1895 is a pivotal date, specifically September 1, 1895, Land Sales and Mining Act, where Texas realized the value of oil and gas and classified lands as mineral lands, making making it mandatory that the state reserve all the mineral rights, leading up to the unhappiness of the surface owners, which led to the Relinquishment Act of 1919 that ended in 1931. So 1919 through 1931, we still have to apply Relinquishment Act lands accordingly, and know that it ended in after the 1931 Land Sales Act. Um, and that is all I have, and I appreciate your time. Thank you.